The Labor Appeal Court has overturned the firing of a Woolworths supervisor who called her colleagues dumb, forcing the retailer to reinstate her. The legal lesson for employers is strict. Successfully proving an employee committed misconduct is only half the legal equation in a dismissal case. To achieve substantive fairness, every employer and arbitrator must assess two distinct requirements: proof of guilt and the appropriateness of the sanction. Failing to explicitly prove why a firing is the proportional punishment makes any termination legally vulnerable, regardless of the proven facts of the offense. Gladys Arunachellam maintained a flawless 28-year record as a supervisor before a 2019 incident where she used a derogatory term in front of trainees to describe her colleagues. A CCMA commissioner initially upheld her termination strictly on the grounds that he verified she used the offending word, but the commissioner made a fatal legal error. He explicitly recorded that he did not evaluate whether firing her was too harsh, reasoning that the employee had not specifically asked him to do so. The Labor Appeal Court defined this omission as a gross irregularity. When an employee files an unfair dismissal dispute, commissioners are automatically obligated to test the sanction. Woolworths did secure an exception on procedural fairness. The court ruled that giving an employee just 15 minutes to prepare a response to a verbal misconduct charge is legally reasonable. Ultimately, the burden of reviewing a sanction's severity falls entirely on the legal process. Employees do not need to independently raise the issue of proportionality to be protected by it. To avoid further delaying a 6-year-old dispute by sending it back to the CCMA, the court bypassed a remittal and determined the appropriate sanction itself, downgrading the dismissal to a 12-month final written warning. The court weighed 4 mitigating factors: 28 years of unblemished service, no racial element, the targeted employees were absent, and the disciplinary code advised progressive discipline. Ignoring internal policy for a first offense makes dismissals highly susceptible to being overturned. The court also issued a secondary warning to arbitrators regarding documentation. Arbitration awards must provide clear, brief reasoning rather than dumping dozens of pages of verbatim evidence transcripts. For employers, the imperative is clear. Long, unblemished service acts as a powerful legal shield. Management must be prepared to defend the severity of their sanctions just as rigorously as they defend the facts of the misconduct.